Hola a todos y a todas, bienvenida a este seminario.
Good morning, everyone. Welcome to this virtual seminar about gender and rules of procedure. I would like to give thanks to the collaboration of Corporación Humana, Comunidad Mujer, from the Faculty of Law, the Universidad Adolfo Ibáñez, and Julieta Suárez of the Red of Politólogas. We're doing this activity, the first of a lot to come, about gender and constitution, as it's a relevant topic, and Chile is a pioneer in having a Constituent Convention, which makes the answer of parity. So we have 4 assemblies from Tunis, Bolivia, and 2 other countries, and they're gonna help us to give lights about what we can do about our process, what we're gonna discuss now in the Constituent Convention to have equality regarding women. We're gonna start with Christina Murray. She's gonna give us an introduction to the topic, and then we're gonna continue with our great 4 panelists. I'm gonna leave with you Erin Houlihan. She's gonna moderate this first panel. And I would like to remember that you have a globe at the bottom with interpretation. You can choose Spanish, English, or the original audio, as we have panelists from different countries, and they're gonna talk English and some gonna talk Spanish. So there you can listen to it. Your question, you can address it in the chat box, where we're gonna have Monica Undurraga moderating questions in this topic. So we're gonna start with this first panel, and thank you very much for being here.
Thank you very much, Maria. My name is Erin Houlihan. I am with the Constitution Building Program of International IDEA. Thank you very much to everyone for joining us today. It is an honor to be able to speak with you. As Maria mentioned, especially for any non-Spanish speakers, to please select at the bottom of the screen the globe for interpretation. I would like to introduce for our first panel, Ms. Christina Murray. To advise the South African Constitutional Assembly from 1994 to 1997. She is a former member of the Committee of Experts that finalized the current Constitution of Kenya during 2008 and 2009, and a former member of the Fiji Constitution Commission of 2012. It's a real honor to have her today, as well as our other distinguished guests. And I hand it over to Christina to please describe to us some broad perspectives on rules of procedure and gender.
Well, thanks very much, Erin, and thanks everybody for being here. It is a true honor for me to be in this group. I think, as you all know, many people are watching with great excitement as you in Chile embark on this process. And I think I probably speak for the other panelists here. When one has been in a process like this in the past, that excitement is even greater because one anticipates some of the challenges and the incredible feeling that success brings. Anyhow, I've been asked just to frame things. I'm not going to specifically talk about gender, actually. I'm leaving that to the panel that follows. So my framework will be fairly general, and I wanted to see if I could share my screen and use a few PowerPoints to help us with that. Right, so I hope you can now see the PowerPoints. Just as a bit of a start, I assume that everyone involved in this process is interested in producing a good constitution for Chile. This is not the moment to discuss what a good constitution actually is precisely, but generally I think one is interested in a constitution that people will respect and support, and a constitution that provides a good framework for accountable and effective government. And that means that in the process, good decisions have to be made. And at the same time, the process itself matters, which I imagine is why you're spending quite some time in working out the rules for your conference. In South Africa, we thought that a good process was also a model for future decision-making in the country, that we wanted our process to be a model of how we could at last come together and deliberate in a constructive and civil way. So that's one thing I think that underpins most thinking about what rules should do, how to ensure a constitution-making body that enables good decision-making. Oh, now I'm not being able to turn. Right. Oops. So again, just framing why rules are important. I've already indicated that one reason is that one hopes rules can help better decision-making. That means one wants an assembly in which one can really deliberate about issues and not simply fight things out. One wants an assembly or conference, as you call it, in which listening is possible and people are encouraged to listen to one another. And of course, one wants clear, good decisions to be made. In other words, the rules are there, in my view at least, to facilitate the process. In English, the concept of a rule often sounds like something that tells you what you cannot do. In a constitutional conference or whatever, I think it's helpful to think of the rules being there to enable and facilitate a good process. Of course, for good decision-making, participants in an assembly or conference need to be well informed. And that means, of course, that there needs to be access to understanding the concerns of people, the options one has, and people need to be open to ideas. So part and parcel of the structure of rules would usually be some mechanism of involving the public, engaging the public. But also, and I put this as a second point, rules are really important in ensuring that everybody can participate fairly, that you don't have some people who command the floor. We all know situations in which someone gets the mic and then never stops talking. We all know situations in which people talk and don't listen. Ideally, rules will have arrangements that facilitate that inclusion. In many situations, women struggle more to be heard than men. I think we hope, you hope, that with the extraordinary achievement of, I think it's over 50% women in your conference, this problem will be reduced. But the idea is that members should be able to participate fairly. And then I've added here that I think the rules themselves can be a kind of signal to the broader public about how they're going to be involved in the process. But by simply putting in the rules clearly that you're going to engage with the public, they become formally part of the process. And I say that particularly because I've seen some of the rules that you've produced up to now, and I'm impressed, and I think it's going to be a model for the rest of the world. The attention you're paying to public, how are you going to engage the public? How are you in fact going to ensure that members of the conference are open to a great variety of ideas and so on? And I'm sure the panelists will talk about this in the next part of this meeting. And then briefly, thirdly, what do rules usually do? So they have to be agreed, as you know, and then so they provide an agreed basis for the way in which the conference is going to run. They need to ensure that it's orderly and that it's constructive. And as I've already said, promote deliberation, sharing of ideas rather than bullying, I suppose, and actually making good decisions. Rules often also structure the process. And again, you've already started doing this because I am aware that you've got a number of transitional commissions sorting out different aspects of the work of the conference. In the longer run, it's quite common to see commissions rather than the plenary, the full conference, as doing the real work. People often speak about commissions or committees being the engine rooms of a large decision-making body. And of course, one of the reasons for that is that in those smaller forums, it is much easier to have subtle, nuanced conversations and a real exchange of ideas. So very often rules, well, usually rules arrange for some kind of committee structure. And ideally, in my view, they also permit new committees and subcommittees to be set up easily so that as needs change, the structures can change. Then rules will very often arrange for some kind of, or set up some kind of agreed mechanism for planning, agenda setting, dealing with problems and so on. The sort of, you might call it leadership or management of the assembly. And critically, in my view at least, that needs to be transparent and accessible to all members of the assembly. So let me use one quick example here. In South Africa, for instance, any member of our large constitutional assembly, it was 490 people, any member of that assembly could actually attend the management committee meetings. But that management committee was just, I don't know, 15 or 20 strong. It varied a bit. So that's an example of ensuring that people don't believe that deals are being cooked behind closed doors. And then, of course, perhaps I've already mentioned this, the structure of the process can also set out how time is going to be managed. And as you all know, time is a really important issue for Chileans. You have comparatively a relatively short time to write a constitution. And then finally, rules, as I've already said, may provide a framework for engaging with the broader public, the media, and so on. But here I think, I can't resist bringing women into it at this moment. Here I think there is a real warning for women. At the moment, it looks to me as if, and I may have read them wrongly, but it looks to me as if your rules anticipate real engagement by members of the conference in getting public participation going. And it's really important, as I've said a few times now, in my view, that members of the conference do engage with the public. But there's also a danger there. Public participation is a hugely time-consuming thing. I have a suspicion that women are often much more conscientious about that than are men. That women will worry about how it's happening and where it's happening. That actually can easily distract women from their primary role in the conference, which is to deliberate on the future constitution. Now, one way that, and let me say quickly, that can also be a way of sidelining women from those deliberations. Women become so involved in ensuring that everyone in society is properly drawn into the process that they can't pay adequate attention to the decisions that are going to matter in the long term. So one thing rules can do to help that issue is ensure that there's a strong framework for public participation, but a framework that, you might say, outsources it. Is it primarily done by a secretariat? draws civil society, the media, and so on in to doing the work of public participation and so on. I'm sure my colleagues here will say more about this. So that would have two benefits. It would have a clear framework so everyone knows, including the public, what's going on. It would allow everyone, including women, on the conference to focus on what they do with the results of public participation and what decisions they should make. And at the same time, it would be an opportunity, or it is an opportunity, for civil society to become more closely involved with the constitution-making process. So it increases the ambit of involvement with the process. And then finally, a handful of sort of fairly general points. Constitution writing takes a lot of time. And as I've already said, and as I've heard many Chileans say already, you have, sorry, I'm jumping around here. You don't have very much time. But also, as the process develops, it changes. Needs change, focuses change. And the process needs to be flexible. The rules need to be flexible enough to be able to adjust without delays to new needs and new demands. Again, let me use South Africa as an example. We moved from having 8 or 9 what we called theme commissions early in the process, dealing with specific subjects, to much more concentrated commissions that pulled things together. We didn't need a change of the rules to do that. We could simply establish ad hoc committees, and we could establish ad hoc subcommittees all the time, with, of course, rules that related to their composition. They couldn't be exclusive, and everything had to be transparent. The public had to be admitted. They had to be accessible to the public. So that's sort of, it's a process, and the fact that it's a process, in my view, means one needs to be attentive to having flexible rules. Then the one I started on, the big job, it's a big job, it's a time-consuming job, and the rules should really ensure, in my view, that the members of the assembly focus on that main job, writing the Constitution, and aren't too easily distracted by many other things. There's important engagement with the public, I know that, but as I've already said, there are administrative matters and organizational matters that can usually be handled by very skilled people. And I think, I'm guessing, but my Kenyan colleague at Sangha, I know, has been deeply involved in that kind of thing. I hope we'll talk a bit about it. And then finally, clear rules, and rules that are easy to implement, not overly complicated, overly open to analysis and interpretation, can help constitution writing. But I sort of feel I need to add here, I think one shouldn't spend so much time on rules, on sorting out the rules, that that time is taken away, time is sort of stolen from the real job, writing a constitution. I don't know whether in your context you have people who may be interested in delaying progress. Most constitution-making processes have people who seek to delay progress in one way or another. I see at Sangha smiling. Ideally, one wouldn't have that kind of opportunity in Chile, and one would focus on getting rules done, tidied, accepted, and onto the main task. So thank you very much. That's just a sort of handful of ideas. I'm sure many more will come out in the next 30 minutes. Thanks, Erin, and thanks, everybody.
Thank you very much, Christina, and also for emphasizing, as you did toward the end, this heavy job of actually deliberating and negotiating and writing the Constitution, and keeping focus on that, and the importance of flexibility in the rules to enable that job to take place over time as needs and demands change. That's excellent framing to lead into our next discussion of how this has looked in several other countries by comparison, because of course, every experience is different. Every experience has its own challenges and opportunities and successes. And so it's a great opportunity to learn from our colleagues. I will hand it over to our colleague, Juliette Suarez-Cao, to introduce the next session and our wonderful panelists. But just to make a note, we see that some of our participants currently have questions. This is great. After our panel, our comparative panel with our country experts, we will have a question and answer session. So please do hold your questions until then, and we will get to them in the latter part of this workshop. Let me please introduce Juliette, who will be leading our next panel. We are very honored that her organization is a co-partner with us. Julieta is an associate professor at the Institute of Political Science of the Pontificia Universidad Católica de Chile. I apologize for my pronunciation to everyone, by the way. She holds a PhD in political science from Northwestern University and is the coordinator of the network of political scientists No Sin Mujeres. She also participated in the design of the gender parity mechanism in the current Chilean Constitutional Convention. Thank you so much. Julieta, please take on your panel.
Muchas gracias, Erin, por la presentación.
Thank you, Erin, for the presentation. Thank you, International IDEA, Human Corporation, Community Women, Adolfo Ibáñez University, for me having this panel so interesting with the protagonists, these conventionalist women that will share their experience, and we could hopefully take notes and apply it to what we're living in Chile. As it was mentioned, we're already ongoing on a journey, on a constitutional journey, and it has gender parity. We know for compared experiences and literature that many times this access to power isn't translated to a real exercise of power. And with this in mind, it's very interesting to hear our guests that they give us ideas on how, through their personal experiences and their knowledge, we could achieve to secure some results closer to gender parity. In this sense, we would like to hear, for example, what norms, what regulations were more useful to facilitate their jobs when they were drafting their constitutions for their countries, what norms for regulations were the most problematic or that give more obstacles for this job for women, and what norms, what rules that didn't have at the time that might have been useful and that you recommend for us to adopt here in Chile. Each of our panelists will have 10 minutes. I'll try to take time so we could hear out everybody and have enough time for questions. And without further ado, for my part, I will present Sango Chisani. She's a lawyer, advocacy for human rights, ex-committee vice president from the Committee of Kenya, ex-delegate in the National Convention of 2005, and ex-director, executive for Kenya Human Rights. We will also listen to Lobna Devi. She's president founder, ex-member of the Tunisian Constitutional Assembly. We also have with us Maria del Rosario Riccardi. She's a lawyer, general director of Training Center and Investigation of Rural Women, ex-member of the Constitutional Assembly of Bolivia, and we will hear Christina Murray. She's from the Constitutional Affairs Unit of the United Nations. She will help us to give some insights for this panel. Retango, you have the floor.
Thank you. Thank you, and good morning. I'd like to just begin by saying thank you to International IDEA and Cooperación Humanas and Comunidad Mujer. Please forgive my pronunciation, I don't speak Spanish. Thank you very much for having invited me to share and speak with you in this panel. I also would like to congratulate my sisters in Chile for this achievement of gender parity. This is a huge dream, and that in and of itself is a major achievement. And I am hopeful that the fact that you have achieved gender parity in terms of representation in the Constituent Assembly will hopefully enable you to be able to ensure that the new constitution that you produce actually respects those principles as well. So just very quickly, Kenya had a constitution making process that lasted over at least 20 years, basically. And when you look at that process, it came out of a popular movement for constitutional reform, which was initiated by human rights organizations, faith-based organizations, and the political opposition. So women's rights organizations actually influenced the Constitution of Kenya Review Act, which was the main regulatory framework that guided the Constitution of Kenya review process. The first one of these review acts came out in 2001. And there is a document which is a report of our National Constitutional Conference that Erin has, and that I hope can be circulated if anybody in the future wants to refer and see. You probably will need to work with somebody to do the translation, but the final report contains in it, of our National Constitutional Conference, contains in it a copy of the Review Act of 2001, which is the one I'm going to be focusing on for the purposes of this discussion, because I think the Constitution, the National Constitutional Conference that we had, which was just one of the stages in our constitution making process, is the one that is most relevant to the particular discussion, because you have a Constituent Assembly in Chile. So that's the one that I'm focusing on for the purposes of this discussion. So when you look at the rules and regulations that we were guided by, it's important to understand this participatory constitution making process, because basically the people who initiated the Kenyan constitution review process, the human rights workers, the women's rights movement, the faith-based organizations, were very committed to principles of equality and principles of human rights norms. And so the people that were drafting the rules and that were creating the procedures that guided our process were people who were quite responsive. They, however, were not the ones who completely determined who the participants in the conference were, but at least we had some room for negotiation because we were dealing and engaging with responsive actors. So then the other thing to remember, and that is important to mention, is that the Constitution of Kenya Review Act itself we had legal obligations. The law required certain things. One, under the law, the new constitution that came out of the process had to respect, had to enshrine the principle of good governance, constitutionalism, the rule of law, human rights, and gender equity. So that our National Constitutional Conference could not, by law, produce a constitution that did not respect gender equity. Secondly, by law, all the organs of review the National Constitutional Conference was considered to be an organ of review. All the organs of review had to ensure that the process itself accommodated the diversity of Kenyan people. And by diversity, the law defined diversity to include socioeconomic status, race, ethnicity, gender, persons with disability, learning, so the level of education, principles of gender equality, socioeconomic status. You couldn't just involve members of the elite, for instance, by law again. And so all the processes that occurred in the making of the new constitution were required by the laws that governed the processes to ensure participation. However, we had a challenge when it came to the composition of the members of the National Constitutional Conference, because I was smiling when I heard Christina saying the South African conference was large, and she just mentioned the paltry sum of 400. In Chile, I understand you have some 150. That's paltry. We were 620 something. And so our National Assembly sat as part of the National Constitutional Conference. Then the other category of delegates were drawn from 3 other groups. Members of the Constitutional Review Commission had to sit as members. We also had representatives from, so the Constitution of Kenya Review Commissioners were delegates, but they were ex-official delegates, which meant that they didn't vote other than the chair of the commission. Then we had the members of the National Assembly. Then we had 3 representatives from each district. And at the time, we had what were considered to be 74 districts. So each district sent 3 members. Each one of those groups that were sent, one of those members had to be a woman. And they could only have 1 councillor representing a district. So only 1 elected member of a local government could represent a district. And they had to ensure that amongst the 3, at least 1 was a woman. And then also, all the political parties that were registered at that time were entitled to send 1 representative. And then finally, we had a group of representatives that were a mixture. Representatives from religious organizations, professional bodies, women's organizations, trade unions, and non-governmental organizations that were registered at that time. Women's organizations were allowed to send representatives as a category themselves because our parliament, only 9% of our parliament were women. So we knew that we would be underrepresented. And so we still didn't quite achieve 1/3 of delegates being female, but in terms of the history of Kenya, this was probably the most representative decision-making body in the history of our country. And that legal requirement that women's organizations had at least 23 representatives helped us quite a bit. Some of the other organizations in that category also were allies. So for example, the NGOs of the 22 members that they sent, 10 were women. Religious organizations sent 34 representatives, 11 of whom were women. And so we saw even the institutions that were not necessarily gender institutions trying to ensure some gender parity in terms of who they sent as representatives. This was mainly again from the non-state actors. Unfortunately for us in our country, our workers the trade unions are very heavily state controlled. So we were not successful with that particular constituency in terms of infusing and ensuring some gender parity. And then for persons with disabilities, half the delegates representing persons with disabilities had to be women. So that was how there was some achievement of some gender parity. So in terms of the rules and regulations, some of the other rules and regulations that helped related to issues such as who were going to be the chairpersons of the vice chairpersons of the plenaries, because the chairperson of the conference was the chair of the Constitution of Kenya Review Commission. And then there were 3 vice chairpersons of the conference elected from amongst delegates, one of whom had to be a woman. We then had rules about how, and regulations with respect to how we sat and how we spoke. And so let me just speak a little bit towards that aspect of things. The rules for the conference themselves were formulated through a standing steering committee of the conference. And this committee was established under the rules and regulations. Again, because of the law about ensuring respect for the principle of gender equality, that standing committee in and of itself, again, had to have representation that respected the principle of at least 1/3 female participation. And of the conference vice chairpersons, one of them, sorry, all 3 of them sat in the steering committee. The conference, on the first day when the conference began, the delegates were required to elect 2 chairpersons, one of whom had to be a man and one of whom had to be a woman, who were the people who were going to chair us in plenary. And so these were the people that represented us both in the steering committee, as well as in plenary. They were the ones that would chair the debates that occurred in plenary. Another rule that was very helpful was a general rule with respect to transparency. So before we would debate any issue, we would have an order paper that came out every single day. So when we came in, we knew, we came into a session, at the end of the day, the order paper that told us what issues were going to be raised the following day would have already been published. And so we would know what was going to be discussed in plenary. We also, in plenary, sat in a very interesting way. The hall where the meeting was happening was an amphitheater. It's a place called the Bomas of Kenya, which has great cultural significance in this country because it's a place where people from all over the country usually traditionally show off their culture. The architecture of that hall, because it is modeled on African architecture, is cyclical. So this amphitheater was cyclical. Now, it was divided into different sections. I can't remember how many they were. I think it was, I would say about 9 sections. And in each section, we had people from all the different constituencies. So basically, each one of those 9ths had delegates seated in there who were women's representatives, who were parliamentarians, who were representing the districts, and representing all the different groups. So when we had a plenary session happening, the chairperson had to give an opportunity to people from each one of those different sections to speak. And when they gave the opportunity, they had to allow for representatives of all the different categories to speak. So for example, you could not go to section A and only allow a parliamentarian to speak. one parliamentarian had to have an opportunity to speak. One person representing women's organizations had to have an opportunity to speak. One representative of districts had to have an opportunity to speak, and so on and so forth, until they had gone round the hall. The only people that didn't sit in that formation were persons with disabilities. Because of the issue of accessibility, they had a special section that was at the top of the plenary hall where they were seated. And they would, each chair, the chair had to ensure that they would also have an opportunity to speak whenever they were going around the hall. So in that way, we all got an opportunity to contribute. Each constituency got an opportunity to input. We exploited the fact that women are diverse to ensure that we got our information out on the floor. So we would caucus with the different constituencies. We would caucus with, because all these constituencies have women amongst them. There are women who are persons with disabilities. So those women will then, we would then caucus with each other to agree how they would use that forum and their opportunities to speak on our behalf. We would caucus with the NGOs to ensure that our issues were raised. So sometimes our issues were not necessarily raised by the women reps. Sometimes they were raised by our allies from these different constituencies. When you looked at the regional constituencies, because historically we have ethno-regional minorities, we caucused with them again and used women from those parts of the country who were district delegates to be our bridge. And this was very important in terms of especially getting through the clauses in the constitution that now require at least 1/3 of the members of parliament, and of all elective bodies, at least 1/3 to be women. Because what we did was use the link between the women who were from other parts of the country to speak to their respective parliamentarians in order to ensure our representation, and our issues were raised. The conference also broke into what were known as technical committees. Oh, sorry, just one thing before I move on to that. When we were in plenary, the chairing of plenary was also rotated. Although the conference chair was the chairperson of the Constitution of Kenya Review Commission, he had the power, and he was Professor Yashpal Gai, a wonderful man. He ensured that that was delegated also to different constituencies. So different constituencies had an opportunity to ask one of their members to chair the plenary sessions. So I, for instance, as a relatively young woman at that point in time, had the opportunity to chair because the women's caucus were asked to elect a chair for the plenary. So let me just talk a little bit about committees. We had technical working groups. They ended up being 13. They were thematic, so they were based on the different chapters of the draft constitution that we were looking at. Those technical committees were allowed to have at most 60 members. Those technical committees were chaired by co-conveners. The co-conveners had to be of opposite sex. And they each had 2 rapporteurs who were commissioners of the Constitution of Kenya Review Commission. So again, we had the fact that we had co-conveners, that the principle of gender parity was respected with respect to the choice of co-conveners, enabled us to ensure women's voices again in those spaces, even when we broke into the technical committees. We used the fact that we were actually showing up, and I know it may sound odd, but our politicians are notoriously lazy in this country, and so they didn't show up. So although they had a huge constituency which was male dominated, the fact that we actually attended our sessions enabled us to be able to move our motions. And so the legislature technical committee, in which as women we were underrepresented, we still were able to move our motions successfully by just by being there and having caucused with each other and worked with women from the regions to get them to speak to the parliamentarians from their own regions in favor of our issues. The other space that we used and that was helpful was that the commission had the power to have observers present, because one of the regulations was that the conference was to be open to the public as a whole. And you could then have observers who were accredited by the commission participate. And so women's rights organizations were part of those observers that came in. They were not allowed to speak on the floor, but they were allowed to observe. And when we were preparing for issues that we felt were particularly important to us as a constituency, but which we may not have the technical competence or ability to push in a way that would ensure a gender responsive constitution, we worked with the women NGOs, with women's rights NGOs, who provided some training for us on the sidelines of the conference. Things that you will not see in the rules, but which were provided for, was the committee then the commission ensured that we would have safe spaces where we could caucus as marginalized groups, and specifically as women. We had a women's tent where we would go and sit and speak with each other. So those are things which you will not see anywhere documented in the report, but which were informal mechanisms that facilitated us. So I'm going to stop there. I think if there are any questions, I'll be happy to take them later.
Thank you so much, Atsango. Really interesting. I love the last part about informal institutions and practices and how we have sometimes to manage to, I don't know, curb or avoid like formal structures to create our own safe spaces. Lovna, it would be great hearing you now. You have the voice.
Hello, thank you for International IDEA for the invitation. Thank you for all of you of sharing these wonderful experiences. I'm really honored to share also the Tunisian experience. And of course, congrats to the Chileans for the gender parity, and it's very wonderful to have this parity in the parliament. Just very rapidly, the Tunisian experience happened. So the drafting constitution, it was after the revolutions and after decades, I would say, of habits of Black parliaments, of, I would say, and this has influence in changing and transformation. So our assembly was composed by 7 committees, which corresponded to the 7 chapters of the constitutions. And the gender was considered in the executive board of these committees. It was also considered in the presidents of the parliament. So our vice president is generally a woman. And even though it's not in the regulation, but it's I would say in habits, and it's acted in all after the parliaments, it become an jurisprudence. I'm sorry for my English is not very. So the constitution was programmed for 1 year, and unfortunately it has lasted 3 years, and it was accompanied by very difficult context of political assassinations, of terrorism, of deeply divided society on ideological issues. And this is very important to consider then the achievements and to consider for gender and for the constitution drafting process and it was accompanied by the huge civil society mobilization and people mobilization in the streets, and this is important. So I was, I would say, during the Constitution, vice president of the first committee constitutions, preamble and fundamental principles of the Constitution, and I was also the main rapporteur of the finance committee. So I accumulated these two huge responsibility during very difficult time. The first question is, what are rules to facilitate the work? I would say the first rule that we have voted before starting the constitution drafting was how would be the process. And the first mobilization was to make the process transparent. We had this Open Gov initiative from the civil society, and where MPs have joined the civil society, really get and supported this mobilization to make first the committees transparent, to make possibility of civil society to be part of the discussion in the committees, and to have media present. And it was very important and very facilitating the correction, I would say, and the reaction of the civil society, NGO, and the participative, I would say, of the voice of the civil society, of right women, civil society, of human rights in general, and all. That was very important. Even in general, in the discussion in the assembly, we have the TV and media, and that was not that easy, because we, as we said, we have decades of a black parliament where no one knows who are MPs and what is happening in the parliament. And this is important to know. The historic weight have very difficult impact on this achievement that we consider a huge achievement during this period, and thus have impacted, of course, the balancing of the discussion and of the constitution drafting, and regarding also women's rights, but also regarding, I would say, the civil society issue, because in our Arabic and Muslim country, we have a discussion on the weight of religion in our and this, the relation between society and between the state and religion is very important, and having sorry, civil society, civil state is very important for us to maintain the human rights for everyone, and of course for women also, that it was a strategic issue. The second, I would say, regulation and rules that was in, and it also had making the participative process, making the process more participative in drafting the constitution, is our discussion and openness also to the regions, to citizens, not only civil society. So we programmed as MPs and committees, we went to regions and we discussed with them, and it was possible for citizens to be in present, and we have our counselors that have written all the proposition, and we have kind of statistics, and that has really changed and impacted also the constitution drafting, and it's very important and make it participative. What I want to say is that the election after the revolution, the results of the election, we have the majority of conservative parties and conservative parties. So if we have used only the arithmetic voices, of course that we won't never have this progressive constitution. As you know, we have the parity in our constitution, we have the equality, we have even the guarantee that the state will fight against violence, and or I would say very as progressive Article 46 in our constitution is not reflecting, I would say, the representative of the weight of the very conservative groups. And this was thanks to the process of the participative approach, the civil society participation, the openness of the parliament, but also the mobilization of the street. And I would say the caucus woman was also problematic. So the caucus woman was problematic because we had a huge cleavage even inside the assembly. And no one wants, I would say, to dialogue. The MPs sometimes are refusing dialoguing with other MPs, if even they were a woman, because this deep cleavage. So it was, the challenge was to make this caucus and to find out within the parliamentary groups of conservative groups, persons, women that were sensible to and sensitive to the progressive, to the human right, to women rights, to women issue. And that was the approach that we have led. And that succeeded because even though we didn't get an official caucus, we have an official. It was not official, but it has played the group, which was not official of caucus, has played a huge role in the drafting of the Article 46. The third, I would say, at the same time problematic, but also issue, is that we have created, after the crisis of the political assassination, and at sometimes in the drafting process, we have broken the activity of the parliament because we have a very deep crisis in Tunisia. What we have done is that we created, after this, and after the national dialogue, as you know, we have the national dialogue that was led by quartet, by organizations, and we have this Nobel Prize, very known, because we have led this successful experience, is that after that we created what we call the consensus committee. And the consensus committee is, I would say, with the arithmetic representative of election. So each political party, wherever they're weighting the election, they are represented by only 2 voices. And so that we have, everyone have one weight, one voice, and the agenda and the possibility of the dialogue has led us to correct, I would say, the constitution, to correct and to make even the Article 46 of parity, equality, and the role of state to fight against violence. These are the 3 principles, were also, I would say, improved thanks to a consensus committee that was created after this national dialogue. What should have been done, I would say, and the third question was, and maybe is for my point of view and my experience, because we are leading, actually, I am president of a think tank which is following the parliament, monitoring and making force of proposition to the parliament after the constitution drafting, is that what we have noticed is when we establish a woman right and a woman gender issue, it continues, even though it's not on the law. So, for example, in our assembly, we were 3rd woman representative in the assembly. So it was not possible to make in the constitution to make less, because, and this was thanks to mobilization of civil society. And so we have to improve. We have to go to not only vertical parity, but also horizontal parity. And this is what we have done for local election. So now for local election, we have 50% of elected people almost are women. And this is a huge achievement. So what I think is that the caucus woman, maybe the achievement would be really to officialize, to institutionalize the caucus woman, because if we have institutionalized it in the National Constitution Assembly, maybe we will have this habits to have in each parliament a caucus woman, and maybe we would have not that difficulty to establish, because now the Article 46 of the Constitution, which is very interesting and would reform a lot of law, we have a difference in the application, and we have difficulty to make it happen in laws and reality. And this has have to be continued through the parliament, through all the caucus women. And unfortunately, there is not this habit of a real institutionalized caucus woman. And maybe I hope that it would be a huge next step to make as achievement for this. Maybe, I don't know if I have more time, or maybe we can get the time for the question.
Maybe we can leave some stuff for the Q&A.
Yeah.
So it would be great now. Thank you, Lobna. María, ¿tienes la voz?
You have the floor. María del Rosario, right? No, Quemada, yes. María del Rosario.
Gracias.
Okay, thank you. We hear you, María del Rosario, and the audience. Remember, you have.
Gracias, María.
Thank you, María. Thank you very much. Right now, I'd like to wish everybody in Chile the biggest success in this constituent process. Congratulate women. I'm so happy for this parity. It's a great responsibility and a challenge as well to have this representation in this historical event for Chile. I wanted to thank IDEA International for this opportunity, Universidad of Ibáñez, Comunidad Humana, to be able to share part of the Bolivian experience. I think when we state ourselves in this event to be able to debate key things in the design of the norms and procedures, rules of procedures, with gender perspective in the Constitution. In Bolivia, we must say that convocational law was a very hard work for 30% at least guarantees participation. And the way that we women should participate it was through political parties only. So with this context, we came to the Constitutional Assembly of 15288 women. Composition of the profile of the constituents was heterogeneous. There was representatives from academia, from unions, from native tribes that didn't have any training, any school at all, but with a lot of organizational experience from the native governments, tribes. Different ways of information. In this sense, it was very heterogeneous to be able to do any training. But nonetheless, if it wasn't in the norms and the constitutional process, the spaces or opportunities for training were enabled, so at least the necessary information to be able to give in to the constitutional process were generated. The spaces were generated by institutions, not by the state, but by institutions that opened training spaces for the constituents. For the women constituents, there were spaces used like lunches, dinners, where we could give little space for training, but they were very important because we were able to dialogue and find ourselves in this diversity and see the challenges that we were facing and the framework of the norms. The law gave us the possibility to participate in 88%. Law also stated that approval of the norms and regulation of the constitution itself should be done by 2/3 because of the law. Article first said us as constituents, we had the power to modify the constitution as a whole. And this generated different interpretations of positions within the constituents of society. That's why in the Constitutional Assembly, I represented socialism movements, the majority force, and we had the mission to go to a foundational constitutional assembly, and then to be able to, the law said that we had over the bodies because the country was being governed by superiors, and this allowed us to see how we would vote and approve our constitution and how we will organize ourselves internally in this constitutional process. And then the debate was generated about the features of the constitutional, and it's in Article 1 of the Constitutional Assembly, and this led us to 8 months of debate because we interpreted, we had the power to define the system for voting, and the opposition found in this article the motive or the pretext, I would say, to stop what was happening in Bolivia. That was a new stage in its history to be refounded as a country and acknowledge its diversity, this diverse composition that it had a lot of exclusion before. We saw this opposition found in this article of the convocational law the pretext to stop the process, boycott, or delay. The situation led on for 8 months, and I think it has to do because of the way the regulation is written, and I find it so important how you guys will work your regulations, as Christina mentioned, with so much clarity, not to lead into interpretations, because this allows us not to take the definitions and within the Constitution as a living case, the topics that have been polarizing to the end, that have had violence and death, could enable the constitutional body to be able to negotiate these topics to stop killing ourselves. It's important the moment that you're living of elaborating the norms to have the clarity and to be able to not lose the opportunity that the constitutional power gives you to be able to define the constitution that Chile needs. Regarding the norms that have been very useful to be able to ease up the job in our constituents, 30%, it's important because it also allowed at least this participation. We had the risk not to come to that because in the parts payment law in Bolivia, we weren't able to apply this, but it was up to 30%. And the inclusion of native tribes with their representation. This, without a doubt, was very important. Building the norms and regulations of the Constitutional Assembly was a really hard process for so many months. And in my opinion, it was just the expression of this polarization that was given of this resistance. Of all of this debate for interest of the changes that were to come about the resources and privileges, simply a platform to the period that we need to be understanding each other, because we came to an article that said we will approve the constitutional so whole by majority rules, We will do this, but we'll center the debate in detail and then we'll approve by 1/3. And those articles that we will not be able to approve by 1/3 because of these positions of these confrontational views, will bring it to the referendum so the people decide. This article allowed us to leave this deadlock that we lived, but we think it was necessary to live to be able to filter frustrations that have been accumulated for exclusion that our country has lived and been submitted to so much of the public. So it was very hard, but it gave a good fruits. To elaborate the constitution defined in the ruling, I highlight as many of the articles look that's participatory in the process to be able to recover what the population wanted. Let's remember that our constitution started from the 90 and it lasted 16 years. Last 3 years as women, we were working in participation process for proposals. More than 20,000 women were mobilized. So this period had placed a scar in the process. For example, the directive of the Constitutional Assembly got all the proposals from all the organizations of the country, and in this document has been worked for the Constitutional Assembly that got all the documents for proposals that came to the directives of the Constitution, and it's open to up to all the 21 commissions. It's a base document for discussion for the commissions. The regulation organized us as constituents with a directive that with a board that had 11 members. 2 of those were women. We didn't come, even though the ruling said that we should include the majority politics also said that they should conform in a plural manner to represent different political parties and people respecting minorities and whatever is possible, taking care of the gender issue where possible. It was expressed that way. We had that limit. We had our board where 11 members, 2 were women. The president, that was a rural woman with a lot of experience, of great character. I don't think we could come to the results as a result without a woman with that character that Bolivia needed. We also organized 21 committees and subcommittees, and this recommendation that I see taking care of the alternativity of gender wherever possible had been the norm that we take care of in each commission, but it wasn't an obligation to guarantee this parity. And was subject to the way us in the commissions could fight these spaces. And in these 4, we had commissions led by women. In these 4 commissions, 3 are union women that proceeded. Isabel Dominguez, the Economical Commission, it's from Teodora Tapia, she's an Aymaran woman, and the Commission from Plural Justice, led by an academic, Rebecca Delgado, and we have a woman from present as well. These are the women that within the 21 commissions that Bolivia had, and the procedure for debating, building, construction of the articles, participation has allowed us to work from listening. Each commission, each subcommission would have audiences to be able to receive different sectors of the country that gave in their proposals, and they had to work on subcommission reports submitted to the commission approved it, and then it would go to the plenary that was approved by the commission. Then, regarding what I held to accomplish the results for women, for the agenda in the constituent women, the work of the subcommissions and the commissions was the most important space. Why? Because of the confrontation Bolivia lived, the debate for the plenary to prove a big scale, not to the detail, didn't go over the barriers that it would have had if we were in another scenario. But to be able to incorporate the articles that we were interested in to set the basis for equalitarian Bolivia, we needed the composition of power with parity. All of this was made possible with the work of the commissions. And for this, the work of the commissions and the constituents, we had to credit for commission for voting, but only one commission. But for other commissions where you had to go and work because you need to guarantee parity there, because, well, if you were independent, well, you couldn't be in the rights and guarantees. There we were, we registered there, and we were in the debate to influence, but you couldn't vote. So you could had a limited power to be able to vote and decide in a commission. From here onwards, women had an important role for our agenda because having a strategic committees allowed us to contribute that the rest of the commissions are able to show our interests, where we had this commitment, this mandate from our population. Having accomplished a strategic relationship with the technical assistance of each of the commissions, it's key, it's important, the work of the technical teams in the constituents, because we see, at least in Bolivia, where we had sisters and brothers that from native tribes or rural, or not precisely, but that didn't understand about the gender issues. We did have limitations. We had this huge barrier to be able to be heard. So I consider that it's so important, this criteria in the regulations, to be able to select the technical staff focuses on gender and the profile. So there are barriers, technical barriers at when you guys are drafting it. Most problematic in the work of the Bolivian Constitution was the law of convocation, when it was talking about the voting system that is able to define the article. We talked about this before, but I highlighted as the worst thing. And what norms and regulations didn't exist, but I do want to exist here. One, I believe the regulation should talk about a mechanism to talk about the constituents for the mandates that it has, for which it was elected for, so that we don't have constituents that come to the constituents not to follow the sovereign mandate, but to boycott the mandate. I believe the regulation should signal out that all constitutions need to have accountability in this regards. There are constituents that cannot say one article that they have been able to give in because they only came to boycott, and that's anti-ethical with the objective that they were elected. Because we have accountability, they need to have accountability for the power they're giving. So I'm sorry. And last of all, this has to do with giving norms that strategically we protect the internal debate and based on agreement with the plural committee of gender equality that protects these debates, because the work of the communication media in our country has been very sad for the constituents. Information left irresponsibly and generated confrontation. There have been some media that wanted the population to do damage to the constituents' lives. And this needs to protect the information, the voice in a democracy concept to fulfill the purpose of the constituents. Thank you, Maria del Rosario. Maybe we leave it for the questions and answers, but it'd be interesting to talk about the referendum as a mechanism for that it was the case for questions and answers. Maybe you could tell us a bit more about that.
Going a little bit over time, but if you'd like to share some final thoughts with us. You can use the voice now. I don't know if Cristina has some like wrap up comment.
Sorry, I didn't hear you. I said, for some reason the translation or you were in the background. I don't think I should say anything now. I think it would be great to have some question and answers from the participants.
Okay, thank you. Verónica.
Bien, muchísimas gracias.
Thank you very much to all our speakers. It has been quite interesting to hear you. I would like to remember that we have a Q&A box for questions. There you can address your questions. I saw one question from Juan Manuel Almanza. He has a question to Sango about the representation of LGBTE movement in the Assembly of Kenya. You already answered with a complete answer. It was only partially considered, and that it was achieved to have a respect rule in the first draft where the conservatives could remove regarding the equal marriage and that other rights, the reproductive rights and human rights, which are very important for the LGBTI groups, they could be defended. They were not present formally, but they could defend some aspects of their rights in front of other constituents. I will also like to review. Please address your questions, and meanwhile, I have a few questions. I would like to do them, specific questions. I'm interested in what Maria del Rosario said. I would like to ask Lorna and Atsango, how how was it possible to address the technical people that supported the constituent members? It's very important to know about it. Which features and which of their features of the technical persons were they elected also by gender criteria, and what did they understand under technical workers? Are they lawyers or what? This is my first question. My second question in relationship to the first one is that usually we have a final committee that harmonize the submissions of the different commissions, a committee that brings the drafts together and draft the final draft. That's a very powerful commission. It has a lot of power because it can draft and can change the intention of what came out of the commissions. What was your experience with these harmonizing committees? Those are the two questions, please. Thank you very much. We could start with Atsango and then Cristina. You're muted, Atsango.
Okay, have I been unmuted now? Okay, sorry, the host had muted me earlier, I guess for the other sessions. Our process was a bit different. We went to the National Constitutional Conference with a draft. In the Kenyan context, we had a Constitution of Kenya Review Commission that was set up, that went around the country collecting the views of the public. They then developed a draft that was circulated. And so they had been in office for about 2 years before we had the National Constitutional Conference. That draft is what was then debated in the National Constitutional Conference. In the National Constitutional Conference, we could make proposals for inclusion, for new inclusions. And we could also make proposals for amendments to existing provisions. Now, for a new provision to be included, it had to be voted for. Generally, provisions were agreed on by consensus. However, if consensus could not be achieved, the issue would be put to a vote. And for a new provision to be included, it had to carry at least 2/3 of conference members. And then there was a very odd rule that if less than a third, if less than a third objected, it could still also carry. Now, women suffered and the LGBTQIA community suffered in terms of numbers with respect to two very important issues as a consequence of this rule. The first issue on which we suffered, the first issue which the LGBTQIA community suffered on was the issue of the equal right to marriage. The original draft of the Constitution respected the right to marriage for everybody. And it gave the right to marriage to anybody who was an adult. Somebody moved a motion, mainly the Catholic Church, during the plenary to have that right qualified to specifically men, and that people had the right to marry somebody of the opposite sex. And so we were unable to defend that particular right. There were attempts to have, there were attacks on reproductive rights as well. We were, however, able to successfully defend the provisions on reproductive rights, except for the right to life, which was then amended very cleverly to define life beginning at conception, which again is a Catholic ideology, but not generally agreed. And so women suffered again on that issue. It was sneaked in through the right to life and not reproductive rights. So those were the two places where we lost out, and we lost because of a numbers game as well, and not quite understanding the dynamics.
Perfecto. Muchas gracias.
Perfect. Thank you very much. Erin was telling me that if participants need to go, that would be okay because we're over the time. And that we still can have 10 or 15 minutes to ensure answering questions of people that would like to stay. So please stay if you can and if you want. Cristina, would you like to answer the question? Please, the floor is yours.
Thanks very much. I thought it might be helpful to hear about the South African Constitutional Assembly with regard to pulling the draft together. Like other assemblies, we had a number of theme committees, and at a certain point in the process, when we were aware time was becoming short, the management committee decided that the drafts, proposals that had come from those committees needed to be pulled together into one document. That work was not done by members of the Assembly. It was done by a technical team. I sat on that technical team as an advisor. Two outstanding drafters sat on that team. It was a small group of 6 people agreed to by the Assembly. And what we did is took this sort of rather varied collection of drafts that came from the theme committees, from the commissions, and put them together into one document. We worked through them, we raised questions. And then different sections went back to the committees that had originally prepared the drafts. So at one period, it seemed as if we worked all night on the draft and then would go back the next morning to the relevant committee. And we would spread out and go to different committees, obviously, with questions and descriptions of what we'd done to alter their work and make the entire draft more coherent. So rather than the draft being given to a group of representatives on the commission and have them sort of become the final holders of the pen, we were called a technical refinement team. Deliberately, that technical language, we did sort of technical work and conferred constantly with the commissions, and those commissions had to agree. Finally, we couldn't do anything. If they seemed obstinate, well, they were obstinate. We usually managed to be quite persuasive, but the final decision-making lay there, and it remained quite diffuse right through to the end of the process. Of course, what was going on in each of those commissions was available to every member of the Assembly throughout the period. So every document was distributed to everyone. Thanks.
Muchas gracias.
Thank you very much.
I'm going to take some questions that came. We have a question that's for Maria del Rosario. We thank a lot for your intervention, Maria. It says, many times the articles approved in the commissions are important or sensitive in regards to gender topics, but when they come back to the plenary, they have gender perspectives in the commissions, but when we go to the plenary, in the plenary, that are modified because there's less women in the plenaries to make it more gender neutral. In your experience, what rules in the rules of procedure could be included to stop this norms neutralization for gender perspective from the commissions in the plenary? That's a question, and I will compile more questions because we have little time. Nicolas Santamaria also asks, do you have experience from any clause anti-political violence and against the gender violence in the constitutional rulings? And what mechanisms were more effective to prevent this type of violence? And also asks if there's an external ethics committee that sanctions violent acts, gender violent acts, and the protocols for violence. And what's the evaluation of work of these committees? I want to add as well here, if there was, to the same question, if there was a lot of discussions about if it was considered hate speech or violence, because in Chile we're forming a discussion about what is considered violence and what should be accepted as a part of freedom of speech from the constituents. So if we like, we start from Maria Rosalia, and then the rest of the panelists could take the questions. Go ahead, Rosalia. You're on mute, Maria. Okay, there we go. I'll try to be concise in the question. The first question is about how the technical staff was selected in the commissions. It was composed in the plenary. Each political organization defined the commissions, and then it was ratified. These commissions, who led these commissions, they qualified the technical staff, and then they would see the profile that they should have. In that moment in Bolivia, there wasn't many people with the gender expertise. This was a specialty that few people had. Or this intercultural focus that for many of the commissions, it was a requirement, the focus of interculturality, the gender focus, but it wasn't always achieved, this profile. And there we find, when we didn't find those technical profiles, that we had barriers there. In regards to the drafting commission, just like political organizations, we all have proposals in the assembly. There was work done with Rapagli was the presidential representation for the constituents. There was implementation of this, finding the agreements and disagreements that were within the political organizations. This was very important for the work of the commissions as well. After producing the work of all the commissions, we brought a constitution with more than 700 articles, and lowering to 400. It was a lot of internal negotiation work, reducing as much as possible. And with all the constituents, sessions for substance, because we had the time pressure and the social conflict, we reduced it to 400 articles, and we had a commission conformed for constituents and representation for each department. This commission was reduced by delegates of each department, that they did the revisions of each of the articles as a drafting committee for the constitution. In regards to the right to life, as it was mentioned in Bolivia, we had that issue, but we had Article 4 that it had to be like states, the influence of churches for the constituents was applied. So, and the right to life was one of the rights that was linked to what if we approved as a right to life, it gives obstacles to the sexual rights. The Commission. This was very clear, and we were able to approve the right to life from conception because fundamentalist thinking was a great obstacle for the other reproductive and sexual rights. We were able to concentrate for these rights. One in this commission. In regards to the last, the commissions, how to do the work with the commission to after modifying, after coming to the plenary. In Bolivia, the conflict that Bolivia had, we were developing an internal strategy. We were working with the members of the board because here we had barriers that could make obstacles for our agenda. So we find spaces to come to the people of the board and the ones that have the possibility to lead the assembly without these gender prejudice and not giving obstacles for our agenda. It wasn't starting from the ruling because in the norms of the rules, anything that guarantees, but having guaranteed these rights coming into the report for the commissions, there isn't the time or condition so that the plenary gives obstacles for this because the interest for those that weren't agreed with the constituents being prioritized in the national debate and coming to the Congress, they're obliged to autonomy, natural resources, or other objectives that they gave priority to. So our accomplishment consolidating the reports, and here came to the final document that wasn't modified in the negotiation commission that approved the articles after the conflict. We had in the regulations in the Constitutional Assembly the confirmation of an ethics committee to see violence or gender and different ways of violence, but there was so much conflict that we weren't able to work it. So we had a high conflict. This didn't play a role. And in the Bolivian case, the right to live free of violence was a debate in the commission because they said, okay, we have the rights of life. Why do you have to say right to live freed from violence? There was a discussion thanks to the alliances in the organizations of civil society that are observant that could state as the freedom to live free from violence, especially in women. Perfect. Thank you very much. I don't know if Love now wants to say anything in regards to the question about the commissions, the harmonizing committee, about the secretary.
Yes, just to add that about the final community and the harmonization of the draft and the real change. In Tunisian experiences, the committee who played this role was the consensus committees. So it was at the same time a committee that was in charge of rebalancing, I would say, and correcting the final draft with a new move and new weight of more progressive and more, which was corresponding to the street mobilization. And what was interesting is that at the first point, when we enhanced this consensus committee, the articles regarding the gender equality and was not in the agenda of the consensus committee. So we made a petition, and this petition was signed by conservative MPs, but by left MPs. And this is also the caucus, the informal caucus has played a major role in going through all MPs and trying to sensitize them to sign the petition. And we have finally like 80 signing a petition, and that was enabled us to make in the agenda of the final consensus committee, the women, gender, and that's thanks to this, we had this equality in the Article 46. Another point is that when it was gone to the plenary session, it was also refused. And so we went back to the consensus committees and we tried to discuss again and again. And there was also a bridge, yani our discussion. We as MPs, we were always communicating with the media about what's happening, because the consensus committee was the only committee that were black, that it was not transparent. And this is, we try to improve again, and it was finally adopted. So there is this comeback between plenary and committees. It's very difficult because it's very linked to a lot of ideological cleavages, and as I said before, it's not corresponding, of course, mainly with the conservative election results. But within the election parties, we have MPs that are really believing and that were really mobilized even in the parity and the woman issue. The last point about the questions that was regarding the violence, and we after the Article 46, we have huge reforms in our laws in terms of fights against violence for women, and we have these laws to make observatory training in the police. The laws are very advanced, and as I said also before, the application had a lot of difficulties to be in the reality, because also there is a lot of mindset changement. We have also to work on the culture transformation, or to work on the regions, and this is also the role of again the civil society that have a huge role to play. So this is the only add that I want to say, and thank you again, the International IDEA, and thank you for this. Yeah.
Thank you very much indeed. Erin, would you have a question? And I think that's the last question we can address.
Yes, of course, unless somebody else has a question, or if the panelists have anything that they would like to share before we close, because hopefully we will be able to wrap up in the 7 minutes. Any of the panelists?
No.
If not, my question was just to ask if each could possibly very briefly comment on the composition and role of the Secretariat. This was something Christina mentioned in her framing issue. And certainly that's very important in this supportive role, and to take some of the burden off committees so they can focus on negotiation and substance. So the Secretariat would be great to hear about briefly before we close.
And I would like to add to that question another question, which is also technical, and probably the Secretary has certain influence on it. How were the topics organized for voting, the packaging of the issues for voting? Was that an important topic for you? Because sometimes it's relevant to split the topics in order to approve some articles, and sometimes it's the opposite. You need to put them together to get a good approval. It's a strategic discussion. Who was thinking about it, and what was your experience? I don't know, who would like to start? Maybe Cristina?
Well, just briefly on the Secretariat, we had a Secretariat, of course, the leadership of which was agreed by the Constitutional Assembly, and it did a massive amount of work. It ran our public participation campaign, collected submissions, brought people to talk to the members of our Constitutional Assembly, ordered the submissions, and of course, critically, constantly reported back to the Assembly on what it was doing. I mean, that can only work if you've got a very accountable and transparent Secretariat. At the same time, there were parts of the Secretariat that were involved in just, producing agendas and material and all the other sort of things that you need a bureaucracy to do. So on that, it was incredibly diverse. And again, the heads of the Secretariat were required to establish a Secretariat that was diverse and so on. I mean, but that is a whole topic on its own. Just briefly on the packaging of the topics for voting, I'm going to say just one thing. We didn't really vote in South Africa. We had a process in which we reached consensus. It was hard. It involved at times, rather than consensus, perhaps compromises. But right at the very end, the full constitution went to a vote, of course, and we required a slightly complicated, but at least a 2/3 majority. But all the hard work had been done before. People lost, people won. But by and large, it was, rather than compromises, a development of consensus. It is possible. Our situation, of course, let me say one more thing. Our situation was different in that the Constitutional Assembly was very party bound. We had disciplined and respected political parties, which is a difference, in fact, from each of the examples, except perhaps Bolivia, that we've been talking about. But nonetheless, I do believe that for many things, consensus is possible.
Muchas gracias.
Thank you very much indeed. Maybe someone else would like to wrap up with a reflection, with a remark.
Atzango, ¿estás hablando?
Atzango, are you talking? You're muted.
Sorry. Okay. Just very quickly, the composition of the body that guides the process. In our case, we had the commission. It was very important to have not just diversity that respects gender principles, but also principles around integrity. Because we had a chairperson that had integrity, he ensured that the people that were brought on board were such as draftspeople, and the kind of laws that were the regulatory framework for the process that was put in place was one that ensured that people wouldn't be able to do things like draftspersons sneaking off and changing things that, that they don't agree with personally. And then I think the fact that we didn't have a secret ballot in the conference itself militated against us as women on the abortion question. For example, the men who were sitting in front of me in the plenary hall were actually complaining that a lot of Catholic priests get girls pregnant. And so why are they complaining about abortion? But when it came to voting, because we had politicians as part of the process, and because they want to be voted for, they did not want to be seen to be voting against the Catholic Church. But I suspect that if they had had a secret ballot, for the voting, they might have voted differently, just based on what they were saying. So thank you very much for having invited me. Those were the two things I wanted to say.
Muchas gracias, Atzango. María.
Thank you, Atzango. Maria, would you like to wrap up? Yes. As you can see, it's a bit of movement here. I would like to thank you all for attending this, for your interesting experiences. There's a lot to write down and to learn for our own constitutional process, as Juliet mentioned, the access to power, and that today we have a parity convention, and the power exercise has to be equal. So thank you very much for your presentation. Thank you to all of you. And thank you for Comunidad Mujer and the Faculty of Law of the University Adolfo Ibáñez. Thank you, Julieta. And I think this can be only one of a lot of activities that we can do in this very intense year that we're facing. Thank you to all of you. In a short time, the record will be able to share. Thank you very much.
Thank you. Bye-bye.
Bye-bye.
Bye, thank you.
Bye.